Thank you, everybody, for joining us here tonight for this installment of the IDCCA virtual training series. Tonight, we're joined by Ed Mullen, who's going to go over ballot access. Just a couple of ground rules before we get started. If you've never joined us for one of these trainings before, everyone will remain muted during the training, but the chat box is open. So if you have any questions, feel free to go ahead and put those questions in the chat box, and we'll have time for Q&A at the end. Feel free to ask any questions that you may have. We're all here to learn, and remember to be respectful of our presenter and our fellow trainees. A few more people here, and without further ado, I will turn the mic over to our president, Christina Zawarek.
Hello, welcome, and thank you for taking the time tonight to be on this virtual training. It's one that is really important because as Democrats, we want to make sure that we're able to get on the ballot and stay on the ballot. And we've got someone with us tonight who knows everything all in and out, I think, about election law, and has been very helpful to a lot of Democrats over the years in making sure that they do stay on the ballot, and or if they're challenged, has been hired in order to defend them successfully, I'll say. Ed Mullen is a lawyer whose practice includes election law as well as employment law, non-for-profit formation and governance, and civil litigation. Ed has advised more than 200 candidates on ballot access in Illinois, including candidates for president, Congress, governor, and offices at all levels of Illinois government. He's prosecuted and defended more than 100 ballot challenges. He's litigated post-election disputes, and he has represented dozens of clients in connection with campaign finance complaints and appeals. Ed has obtained 4 favorable opinions from the Illinois Court of Appeals and 1 from the Illinois Supreme Court over just the past 2 election cycles. So he is eminently qualified to provide the training for us tonight, and I appreciate that he's taking the time to be with us. Thank you, Ed, and I will turn it over to you.
Thank you very much, Christina. And thank you all for joining us tonight for this training on ballot access. And as Christina said, ballot access is extremely important. If you are not on the ballot, you can't win an election. If you are not on the ballot, you've lost the election. So it is critical to make sure that if you are running for office, that you get on the ballot. And people often refer to the term election law, and Christina did in the introduction, but election law is really a compilation of different laws. So depending on what office you run for, different laws and multiple different laws might apply to your candidacy. And so one of the first questions you have to ask yourself when you run for office is, what law actually applies to the office that I'm running for? So for instance, the Illinois Constitution has rules such as for your residency requirement, your age requirement for a number of offices. So if you're running statewide in Illinois, you're running for General Assembly, or you're running for judge, some of the law that applies to you is from the Illinois Constitution. If you're running for a federal office, such as for Congress or for president, the US Constitution governs things like your age requirement and your residency requirement. Once you get beyond the general rules that are set forth in the Constitution, most of the specific law relating to the type of petitions you need to file and the documentation you need to file, where you file it, when you file it, etc., is going to be found in the election code. There is also some other state law that might apply in addition to the Illinois election code. So for instance, if you're running for a county office like county commissioner or county chair or county treasurer or something like that, the county's code is going to have some law within it that is relevant to what you're required to do to get on the ballot. In some political subdivisions, there are also local laws and referendums that are going to affect your ability to get on the ballot. In this particular election cycle, those are much, much less frequent than in the municipal election cycle. So if you're running, for instance, for General Assembly or for judge, those things are not something to worry about. Where you find all of these different laws pulled together to show you what you need to do for your specific race is generally in the candidate guide that is put together each cycle by the Illinois State Board of Elections. And so the 2022 candidate guide is not out yet. It will be out probably in early November. And the reason they're holding on to that is because the Illinois State Legislature goes back into veto session in October, and they're just concerned that there may be some changes to election law in the veto session. So they're holding back the candidate guide until early November. So if you are running for office in 2022, you should pay attention to the Illinois Board of Elections website. And when the candidate guide is published, you're going to want to take a look at that and see what information they've provided for the specific office that you're running for. So as an example, let's see, why is it not letting me move the, it's doing that again. It is not letting me move. Okay. I don't know how it let me do that, but it did. There we go. All right. They don't teach this in law school. So the candidate guide is going to pull together the information from all of those different sources. So from the election code, from the Constitution, from the county's code, whatever applies, and it's going to put all of that information together for the office that you're running for. And so you want to take a look at that. But I pulled up some examples from the candidate guide to show you what it would look like. And so if you go to the page for Illinois State Representative, it's going to tell you that you have to be 21 years of age. You have to be a US citizen. You have to live in the district for 2 years prior to the election, and you have to be a registered voter. And so those are the qualifications for the office. It also gives you information about the number of signatures you need, when you need to file, and it gives you a link to a sample petition for that petition, or for that position, a sample statement of candidacy, and information about your statement of economic interests. So looking at the candidate guide is going to give you the specific details about what law applies to your race and what rules apply to your race. And so you need to make sure to check that, because some of the things that I'm going to talk about are going to wind up not applying to you because of the particular race that you're running for. So the first question you want to ask yourself if you decide to run for office is whether you're legally qualified to be a candidate. One of the first requirements you need to think about is the residency requirement, and we're going to talk about that on the next slide as an entirely separate topic. There are age requirements for many offices. There are some offices that have a license requirement. For instance, if you're running for judge, you have to be a licensed attorney in the state of Illinois. You can't have been convicted of a felony or an infamous crime. If you have been convicted of a crime and you're not sure whether or not it's an infamous crime, that's something you want to check out with your attorney, because it's actually not very clear what an infamous crime is right now, because the statute doesn't define it anymore. So if you have something that you think might be a barrier, you want to make sure to check that with an attorney. You can't hold incompatible offices. Now, you can run for an incompatible office. So if you have one office and you run for another and then resign, but you want to make sure that if you want to keep the office that you currently have, if you have one, that you're not running for an office that's incompatible with it. And in order to find that out, the Attorney General has opinions on the Attorney General's website that talks about what offices are compatible and incompatible. But if you're not currently holding an elected office, that's not relevant to you. It used to be the case that if you owed money to the political subdivision you were running in, you could not get on the ballot. But now that law has been changed, so you can still run, and if you win, you have to pay it before you're sworn in. But a lot of people are going to tell you that if you owe money to the political subdivision, you can't run. But you can run, you just have to pay before you're sworn in. There's also the Ballot Forfeiture Act, which is If you have a campaign committee that is fined by the State Board of Elections for campaign finance violations and you don't pay those and you have fines that are due and owing, the State Board of Elections can keep you off the ballot under the Ballot Forfeiture Act. In most instances, you also need to be a registered voter in the political subdivision that you're running in, although for some offices that's not the case. So you need to check to make sure you need to be a registered voter, but I still recommend, regardless of what race you're running in, that you do become a registered voter in the political subdivision that you are running in before you start circulating your petitions. So once you've gone through all of those requirements, you ask if you've satisfied the residency requirement. The first question here is whether there is a residency requirement for your office, because some don't have them. So for instance, if you're running for Congress, you don't need to live in the congressional district that you're running in. So first check to see if there is a residency requirement, and most other offices do have one. Then you need to understand the length of the requirement and how it's calculated. So for instance, we looked earlier at the Illinois State Representative and we saw that that's a 2-year residency requirement, and it's measured from the date of the election. So it's not measured from the date that you're sworn in. It's not measured from the date that you filed your petitions. It's measured from the date of the election. There are other offices that are measured at different places. So you need to understand both the length and when you calculate it. Residency means, for election law purposes, physical presence plus the intent to remain. What that means is you need to be generally physically present, sleeping, spending your time within the district, and you need to intend to remain there. In order to abandon a residence, you need to establish residency somewhere else, which means you need to have a physical presence somewhere else and you need to intend to remain there. So if I become a resident of the 49th Ward in the city of Chicago, I don't abandon that if I am not physically present in the 49th Ward until I establish an intent not to remain there. So understanding that physical presence and an intent to remain establish residency, and you don't abandon your residency until you have physical presence and an intent to remain somewhere else, is important. And there are cases that are very complicated that have gone up to the Illinois Supreme Court on what it means to be a resident and what it means to abandon your residence. But you want to try to make this as simple as possible and show that you have physically lived and shown an intent to remain in the district that you're running in for the length of time that you're required to for the residency requirement. For election law purposes, you can only have one residence. You can have multiple houses in different parts of the state in different states, but for election law purposes, there's only one place that you are legally entitled to vote from and to run for office from. There are a lot of people who will have different places. They've got relationships, they've got their parents' house that they used to live at for 20 years and then they moved out of. And so sometimes it's not clear cut what your residence is. But what is 100% clear cut is that if during the residence period, so if you have a 1-year residency requirement, if during that 1 year you voted from another address than you're trying to establish your residency at, you cannot do that. So I have had cases where someone has said, I live in this place, but I voted somewhere else because that's where I was registered and it was easier. That disqualified them from running for office, simply voting from an address that was in a different district than where they lived. So that is the one thing that is going to disqualify you from running, is if you vote within the residency period in a jurisdiction other than the one that you want to run in. There is no, other than the voting in another district, there's no clear-cut thing that establishes residency or disqualifies you from residency. But the things you want to be thinking about is your driver's license, your voter registration, where your bills are addressed to, where you take a property tax exemption. Because if you're swearing that your homestead exemption comes from a different place than you're registered to vote, then essentially you're swearing that you have two separate residences, and that's potentially going to get you in trouble. The other thing is this is all public information. So your opponent may go and try to look at what your public documents say about where you live and try to argue if those are different than what you used as your residency for purposes of your election, that you are not a resident. I'm going to look at these two questions really quickly. We're going to talk about redistricting next. And we're going to talk about, okay, two questions about redistricting, which is the next bullet point. So we are in a redistricting year. What that means is that the district that you live in now may not be the same district after redistricting is passed. So here is the general rule. If you live in a district now and you have lived in the district now for the length of time that is required for residency, you can run in whatever your new district is. Even if you now live in the 10th district and, you know, at the end of the year, you live in the 11th district, because you live there, you can run in the 11th district. You can also run in any other district that contains any part of the district you used to live in. So it's not just where you live that determines how many places you can run. It's the entire district that you live in. If any part of the district that you currently live in is part of a district after redistricting, you can run in that district. So if you currently live in the 10th congressional district or the 10th representative district, and that's split up into 3 separate districts, you can run in any one of those 3 districts, even if you don't live in them now and you've never lived in them before, because you've established residence within that entire district, and you can run in any district that has part of that district within it. If you win, you have to move into that district, and the amount of time you have depends on the office you run for. But typically, you know, if you're a state representative, you've got to move within 6 months. If you're a state senator, it depends on whether you're in a 2-year cycle or the 4-year cycle, but you basically have to be in the new district 18 months before you run. So that is not very simple, but that is the rule with redistricting. So you may have multiple districts that you are qualified to run in the redistricting year. And again, that's the kind of thing where you want to, you know, consult someone who's a lawyer if you have any questions about that, and if that's an issue for you. Okay, so once you've determined that you're qualified, the next question is how you get on the ballot. So you have to file nominating petitions, and we're going to talk specifically about the petitions. You have to file a statement of candidacy, which is a 1-page document that says that you're qualified for the office and you intend to seek the office, and it has to be signed and notarized. You have to file a statement of economic interest, and we're going to talk on another slide in more detail about that. There are 2 other documents that you may see or hear about. The loyalty oath, that says you're not a communist and you're not going to overthrow the government. It's been deemed unconstitutional. You don't have to sign that, but if you want to, you may. The Code of Fair Campaign Practices has a 1-page document that says you're going to follow a series of fair campaign practices. Signing that has no impact on your ability to access the ballot. So the required documents are the nominating petitions, the statement of candidacy, and the statement of economic interest. The nominating petitions, you want to make sure that you have the statutorily required language. And to start that process, you're going to look at the candidate guide and you're going to find your race. You're going to click the link to the petition, and you can either use that form and fill it out, or you can use that as a template, or you can hire a lawyer to draft one for you, but you need to make sure that all the required language in the statute is in your petition. The circulation period this cycle is going to begin on January 13th, 2022. You can file your petitions between March 7th and March 14th of 2022. This is shorter than the normal 90 days. It's closer to 60 days. March 7th is the first day to file. If you file your petitions the first minute the office where you file them opens on March 7th, then you go into a lottery where you can possibly be the first candidate listed on the ballot. If you show up a minute after the office opens, you do not go into that lottery. And then you have until 5 o'clock on the 14th to file your petitions if you need that additional time to get the signatures. Each office has its own number of signatures that are required. Because the petition circulation period has been shortened, the number of signatures has been reduced by about a third. So for instance, to run for governor, it normally requires 5,000. Now for just 2022, it requires 3,250. So you need to make sure that you understand the number of signatures that need to be filed. When you file your petitions, all of the documents that you file need to be bound together and numbered. If they're not bound and they're not numbered, you can be knocked off the ballot. You also want to make sure you file in the right location. General Assembly state offices are at the State Board of Elections in Springfield. You have to go to Springfield. You can't go to the office in Chicago. Most county offices are in the county clerk's office. A lot of judges think that because they're running for the county court that they're a county office, but they're actually a state office. And so any judicial candidate needs to file in Springfield. So just make sure that you're filing in the right location, and that will be listed in the Board of Elections candidate guide. Here's a sample of the petition. I don't want to spend a lot of time going through this, but you make sure your name is exactly as you want it on the ballot, and hopefully that matches up with what's on your driver's license and your voter registration, so that there are no concerns about whether you're using your proper legal name. And so you make sure that the top of the petition is filled out. There's a circulator affidavit at the bottom of the petition, and this is really important that it's filled out correctly, that you have the name of the circulator, the location of where the affidavit is notarized, that the circulator fills in all of the information about their circulation and signs it, that they sign it before a notary, that the notary fills it out, the notary signs it, the notary stamps it, and the notary dates it. So in order to be notarized, it needs to be signed, stamped, and dated. So how do you circulate the petitions? Let's go through some rules. All of your circulators need to be 18 years of age and US citizens. They don't need to live in your district. They don't need to live in the state. They don't need to be registered voters. All they need to be is 18 years of age and US citizens. If you have someone who is 17 years old and they will be 18 by the next election, and they're able to vote in the next election because they're 17 and about to be 18, they can also circulate petitions. When you're circulating the petitions, you want to ask the petition signers whether they're registered to vote at their current address in the political subdivision. A signature is only good if the person is registered to vote, their registration is at the address that they put on the petition, not some other address, and that address is in the political subdivision, in your district, in your county, etc. So it needs to pass all of those three tests in order to be a valid signature. The signature needs to be from the registered voter. It needs to be genuine. That person needs to have signed it themselves, not their brother or sister or their parent. Needs to be this petition signer himself or herself that signs it. The circulator needs to be in the presence of the person when they sign the petition. Don't leave it on a counter at a store and, you know, let other people sign it as they come in and out of the store and then come pick it up at the end of the day. You've got to be there when they sign it. Again, the affidavit needs to be completely filled out and notarized. Once the petition is filled out, you should not alter any information on the petition. Don't go changing the address. If you look up someone's name in the voter file and the address is different in the voter file than it is on the petition, you don't have the right to change that. It's not a good signature if they didn't put down their correct address. There are issues that come up with pattern of fraud. You want to make sure that when you have someone that goes out and circulates petitions for you and they bring them back, if it looks like a lot of the signatures on the page have the same handwriting, you want to think about whether or not you're gonna file that. Obviously, you're not going to do that intentionally, but people cut corners all the time, and you want to make sure that you're not accused of a pattern of fraud because one of your circulators did something that they shouldn't have done. So that is the petitions. The other main document that gets people in trouble is the statement of economic interest. And this is a requirement, it's an ethics requirement for disclosing financial information that might cause a conflict with the office that you are seeking. So the statement of economic interest is a form, it's a 2-page form, and you can find a copy of that on the State Board of Elections website or on the county clerk's website if you're filing it with the county clerk, but the questions are generally the same. You need to put your name, your address. You want to make sure that those match your name and address on the petition, and then list the office that you're running for. You also want to put none or not applicable as an answer to the question if you don't have any conflicts. And the reason I say that is not because you're going to get kicked off the ballot, but because people often object to that, and you wind up spending a lot of time and money defending a stupid objection just because you didn't put none as an answer to a question on the statement of economic interest. And I had a case that went all the way up to the appellate court on that question, and they lost it every step of the way, but they just kept doing it because they had money and they wanted to annoy my client. And so you want to avoid that. The statement of economic interest itself, the way you fill it out is almost never going to get you knocked off the ballot. What's going to get you knocked off the ballot is if you don't file it correctly. So you need to make sure that you file it during the petition period, either with the Secretary of State or with the county clerk. It is the only document that you don't need to file bound with all of the rest of your petitions. So you can file your petitions on March 7th and then come back on March 14th with your receipt or your statement of economic interest. It's the only document that does not need to be filed together with it. You file it if you're running for a state office with the Illinois Secretary of State. You take your statement of economic interest, you file it with the Illinois Secretary of State, and you get a receipt. And it's the receipt that you file with your petitions, not the original statement of economic interest. If you're filing with a county office, the county is where you file your statement of economic interest, so you can file the original with the county. So if the office where you're filing your petitions is the same as the office where you have to file your statement of economic interest, you can file the original with your petitions. If the office requires you to file your petitions in one place and the statement of economic interest in another place, you have to file the statement of economic interest in the correct place and then take the receipt for filing it and include it with your petitions, not the original. This is something that is very technical, but you've got to make sure that you get it correct because this is something that can easily knock you off the ballot. How many signatures on a page? You decide that. So you can use the form, and some of them have 10, some of them have 15. Or if you create your own using the form, you can put 12, you can put 17, you can put 20, as many as you think you can fit on a page. There's no requirement there. The statement of economic interest cannot be filed in Chicago. It's got to be filed in Springfield. So hopefully you do all of this correctly and you don't get an objection. But any voter who's registered within the political subdivision can object to nomination papers. So anyone who lives in the district, now typically it's going to be your opponent or someone that supports your opponent, and they're going to find someone in the district to do the objection and to be the face of the objection. But any registered voter can file an objection. They have 5 business days after the last day to file the petitions to file an objection. And so the petitions are due on March 14th. So 5 business days after that is going to be March 21st. So in the evening of March 21st, you're going to check and see if there's any objection to your petitions. And if there's not one listed on the county website or on the state website, then you haven't been objected to and they can't file one on Tuesday or Wednesday. That's the last day that they can file it. One thing to remember, though, is that there are no sanctions for filing frivolous objections. And what that means is that a lawyer or any individual can file an objection without concern that they're going to get fined or sanctioned for filing something that's frivolous. So in federal court, there's what's called Rule 11. In state court, there's what's called Rule 137. And those say that if you file a frivolous document with the court has the right to sanction you. Attorney's fees, fines. The Board of Elections doesn't have the authority to do that under the code. And what that means is that people often get away with filing things that are very frivolous. And so it's really important not only to say, okay, what do I need to file passable petitions and nominating papers, but what do I need to do to avoid an objection? So try to get 3 times the number of petition signatures that you need. Make sure that you have everything numbered, that you have it bound, that your statement of candidacy is signed, that it's notarized, that you check the notarization of each of the petition pages. Those are easy things to object to, and you want to make sure that you don't hand them anything to object to. The hearing process is extremely expedited because ballots need to be printed and people need to start voting. So you're going to have a hearing for an objection about a week after the objection is filed, and it could take 2 weeks, it could take 3 weeks. In some instances, it takes 5 or 6 weeks. Sometimes you go up to the appellate court, sometimes you go all the way up to the Supreme Court, but it gets rapidly expedited, and it takes a lot of time, and it could potentially cost a lot of money, which is why making sure that you're following all these rules is really, really important. And there's my information. So I went through that really quickly because I took too much time last time I did one of these trainings, and I tried to cut it down and focus on the things that were most likely to keep you off the ballot. The reality is that I could have spent 45 minutes just on residency, or I could have spent 45 minutes just on pattern of fraud. And so what I've tried to do is give you, a taste of each of the pieces of the puzzle, because you don't know what you don't know. So now you know what you don't know. And if there's anything further you need, you really want to go to the State Board of Elections candidate guide. You want to talk to, whether it's your county party, your attorney, whatever, to get kind of detailed information about what is required. But that is the overview of how you get on the ballot to run for office in Illinois.
Well, thank you, Ed. A reminder, if you have any questions, feel free to go ahead and put those in the chat now. We've got some time for Q&A here at the end. I did see a question earlier going back to the petition process. Can the circulator fill in the address for the signee, or do they have to do that all on their own?
Yes, so the circulator can fill in the address for the signee. So legally, the only thing that the petition signer needs to actually do in their own handwriting is their signature. My recommendation, though, is that your circulators only put in someone's address when, you know, they've got they have difficulty writing it themselves. So there are a lot of instances where where a circulator will try to be helpful and they'll write all the addresses. And so when someone is looking at it from a potential objection standpoint, they see that there's 10 or 15 addresses on a petition that are all written in the same handwriting. And that gives them reason to think that, oh, look, maybe this is fraud. And so maybe it's not, but to prove it's not fraud, you know, they're going to file an objection. They're going to say it's a pattern of fraud. The hearing officer is going to look at the document and say, yeah, it looks like all these addresses were done in the same handwriting. And you're going to have an evidentiary hearing, and that circulator is going to have to come in and testify that, well, yeah, I wrote all these out, but each individual signed it. And then you're going to have a couple of the people who signed it come in and say, yes, this was my signature. So while the legal answer is that, yes, the circulator can do that, the practical answer is that if the circulator does that for all of the signatures on a page, that's going to be an issue. Let me talk about two other random things, since we've got a little more time, that are things that have been objected to recently. One is, and I alluded to it a little, is changing the address after the petitions have been circulated. So what happens is you decide, I'm going to vet my signatures and I'm going to determine whether or not a signature on the page is valid. So I know how many valid ones I'm putting in. So I look up person X who signed the petition, and they have one address on the petition. But I realized that, oh no, they moved and they haven't changed their address yet, and this is how they're registered in another address. You cannot cross off the address, even though you're able to write the address down for them. You cannot cross off the address that they wrote down and put in the address that they're registered under. You can't do that. And that has been, there was a case where someone was found to have committed a pattern of fraud that went up to the First District Appellate Court, and that candidate was kicked off the ballot. One of the other things is that the circulator is required to put down their address on the circulator affidavit. And so what some people do is they look at the name of the circulator and they check to see whether the circulator is registered to vote at that address. And if not, they object that the circulator lied on the circulator's affidavit in saying where they lived. And sometimes when you hire circulators, they don't want to put their real address down because they don't want to get a subpoena to show up at a hearing. Or sometimes they're transient, and they've got a driver's license at one address, they've got voter registration at a different address, they spend time at another address, and so you want to make sure that your circulators know that they need to put down their real address when they're signing the circulator affidavit. And you should check to see whether it matches their driver's license. And if you can look up their voter registration, because your opponents, if they're really looking for something to object to, are going to look at that.
It looks like we also have a question. What is the legality for going into nursing homes for collecting signatures? So
most the nursing homes will only let you in based on their policies. So if the nursing home lets you in, it's perfectly legal. If the nursing home doesn't let you in, then you shouldn't do it. It's really not a question of election law, but the nursing homes have very strict policies now about who can come in during COVID, and I think it's going to be extremely hard to get signatures in nursing homes during COVID. And then there was a comment about the signature needing to match. I mean, the signature that is on the petition should match the signature on your voter registration card. And if you register to vote when you're 18 and you don't change your signature and you're 65 years old, your signature may be very different. than it used to be. So the rule is that it is presumably good if it matches. If it doesn't match and you've been objected to, what you wind up having to do is run around and get affidavits from people, and you have to get them to sign under oath that, you know, this is my signature, here's my driver's license, here's some other indicia of proof that this is who I am. And that's a pain because, you know, you've got 24 hours before an evidentiary hearing and you've got 10 people running around the district at night with a notary in their car trying to get affidavits from people that they signed the documents. And so one of the things that I mentioned earlier was vetting your own signatures. And that's something that I advise all of my clients to do, because you can take your petition sheets that you've gotten signed and you can bring those down to the Board of Elections, and you can sit with their computers and look up their voter registration and their signature card and make sure that it all matches. So you can determine whether your signatures are good or not. And so when you file them, you know how many good signatures that you're filing, and you know how many are not going to survive a challenge.
And Ed, where can someone go, where can a new candidate go to figure out how many petition signatures they'll need?
How many they'll need? That'll be in the State Board of Elections candidate guide. So if you're running for state representative or state senate or state office, those should be really easy. Those are in the statute. They're easy to determine. I don't remember them off the top of my head. It's for state representative, it's 5,000 or it's 500. I think it's 400 this year. And then for state senate, it's generally 1,000. And I think it's about 65% of 1,000. What's that? 650. So those are the numbers. And then for county offices, you're going to have to go, it's done using a calculation of how many people voted in the last election for the highest vote getting Democrat times a certain percentage minus a third. And so what you typically do is you go to the county and or the Board of Elections guide and look at what that is. And if you have any questions, you know, then you're going to just have to call someone with experience in figuring that out. But the General Assembly numbers are set by the statute, and the others have calculations that you have to go through you have to go through a couple steps before you can figure out what that is. And so, you know, each county is going to have totally different numbers.
We had a question about challenges. If there's one bad signature on a sheet, is the entire sheet thrown out or just that signature? Just that signature.
So if a signature is bad, that signature gets thrown out. If the circulator doesn't sign the petition or the notarization is bad, then the whole sheet is bad, because the circulator filling out the affidavit and the notary relates to the entire sheet. So you could have, you know, you could submit 10 signatures on a sheet and 7 of them are good and 3 of them are bad, and then that's totally fine. But if it's not notarized, they're all bad.
We also had a question about petitions for referendums. Are there restrictions on when they can be circulated?
So not the same way. There are 2 different types of referendums. So you have referendums where on the petition it says what election they're for, and others that just say not more than 90 days or 92 days after the election at which they're submitted. But generally there's no, you know, you can start circulating petitions now that you're going to submit for the June or November 2022 elections. And then the question of, are they going to reduce the signatures more for COVID? I think the answer to that is most likely no. They did that the first election cycle for COVID, but they didn't for the second election cycle. So the municipal race, there were some individual candidates that got on the ballot because they made arguments relating to COVID. but there was not a general reduction of signature requirements because of COVID for the entire municipal election. And so if there wasn't for that election, I don't anticipate one for this election when they're already reduced.
I had actually had a question, Ed. You had talked about not striking or changing someone's address on one of the petitions. Can you talk a little bit about the striking pages? Like, I would assume that the candidate is still able to strike a signature and turn in, I forget what the name, the technical name.
Certificate of deletions.
Thank you.
Yes.
Correct.
So,
yeah.
So this is one of the things that I cut out of the,
Sorry.
no, that's okay. So in a lot of races, you have a minimum and a maximum. So for a state representative, you have a minimum and the maximum is 3 times the minimum. So you can, in a normal year, the minimum would be 500 and the maximum would be 1,500. Right. So what that means is if you submit 1,500 signatures, 33% of them have to be good, which is a fairly low rate. So most people should be able to get by submitting 1,500 signatures and having 500 of them be good. But if you want to, if you have people that go out and you get 2,000 signatures, you can submit your best 1,500. And the way that you do that is by deleting the ones that you find out are bad. And in order to delete them, you have to take a line and cross it through the signature. Either the circulator or the candidate has to write their initial next to the line. And then you need to attach on the back of the petitions a certificate of deletions that shows the line and the page number of each signature that you deleted. And if you do all 3 of those things correctly, that signature does not count toward the maximum. So a signature that you know is bad will not count toward the maximum, which means that a signature that you know is good on one of the lines below it will count. So, you know, if you have 2,000, you can delete 500 of them, and that means that you're submitting, you know, rock solid 1,500 good signatures, because you've deleted 500 that, you know, they weren't registered, they put down the wrong address, they didn't live in the district, whatever was wrong with that particular signature.
Thank you, Ed, for that clarification. The other thing that I would just say is that, you know, that's we're talking to most of our folks online here, as many of them, I think, in the scroll through are possible or potential candidates. And one of the things that I would encourage, and Ed mentioned this earlier, is making sure that when you're running for office, if you should choose to do so, that you reach out to your local county party, because they can help you get those signatures. They can also come back around and check your petitions just to make sure that things are good. They may also have other resources, especially if you need to go in and perhaps go to the local election authority or the county clerk's office to check signatures on your petitions. So it's a good resource. And what it seems to me is that, Ed, that what you're saying is, you know the rules, have a plan, and get more than you need, to boil it down.
Yeah, I mean, I always say, you know, I always tell my candidates we want A pluses. You know, a B will get you on the ballot, but you want an A plus because you don't want to go through the hassle of a challenge. Because if you get challenged, you know, it's hard to fundraise while you're being challenged. It's hard to get volunteers and to get endorsements while you're being challenged. It takes your psychic energy and your momentum. And so, you know, you want to do everything right, so that, you know, if a frivolous objection is filed against you, you know, you don't spend any time worrying about it. You just take care of it, because it can really derail a lot of campaigns, even if it's not successful.
Exactly. Did we have any other questions for Ed while he's here?
I don't know if I mentioned at the beginning, but we did record this presentation, and everybody who attended tonight will get a link to that recording. So if there's any parts of the presentation that you want to go back and visit, you will be able to do so.
And then I would just add one last thing that most of our county parties, and certainly I think at the IDCCA, we will be doing another virtual training session specifically for our precinct committee people in passing petitions and how to do those as well, a little bit more in depth. And many of our examples will have some of our petitions samplely filled out just to make sure that people know what goes where, because sometimes it can be confusing on the language. So we'll add that, that training coming up as well. And if we have nothing else, I'm going to say thank you, Ed, for taking the time tonight. I'm sure I will see you in the neighborhood. And thank you everybody else for being on the call. And certainly if you have any other questions that pop up, please don't hesitate to reach out to myself or to Jillian, and we can make sure we get those questions answered. Thank you again for tonight, everybody, and we will see you soon.
Thanks, everyone.